legislation that's been introduced does a number of significant things. It sets out the framework by which decisions on whether to use an audio-visual link in court proceedings can be made. It stipulates actually a default position, just speaking further to a point made by Leanne Dalzell, that a decision should actually be made in favour of using AVL in any criminal procedural matter unless the judicial officer feels that there's sufficient reason not to, or there's an objection from another party. AVL in a criminal substantive matter is also allowed by application, so long as the judicial officer is satisfied that the criteria for the use of AVL would be met. And AVL can be used in civil matters. In those cases, it can be used even if a party does object, so long as the judicial officer considers that the criteria can be met, so that AVL is appropriate in the circumstances. There are clearly 5 benefits which other speakers have mentioned in the use of AVL: reduced costs through not needing to pay for transport of participants from one location to another; improving court efficiency by not having to wait for the transportation of the parties. Anyone who's sat through a criminal call-over in the district court will know how inefficient that process is in terms of judge time or judicial officer time, lawyer time, and just the time of potential witnesses as well as the parties. As Chester Borrows indicated, there could be, if this system is administered properly, increased safety and security. There ought to be the facility for increased access to justice, rather than people who live in centres where there are many courtrooms and many judges having the expectation of speedier justice than those, for example, living in rural areas relying on circuit judges or having to travel to larger centres for the administration of justice. And it ought to be able to improve the quality of evidence heard in courtrooms, assuming we get the technology right. The main concerns here, obviously, with extending the facility for AVL will be the difficulty of participants to truly interact with a judge, with counsel, and with witnesses. So any lawyer in the House and many other members will know that in cross-examination, for example, and the giving of evidence in chief and re-examination, the reactions and the emotions expressed by a witness or any other participant in civil proceedings, let alone criminal proceedings, are vital to a judicial officer or a jury making decisions or assessments of fact. And it will be essential, sir, to make sure that the technology that's deployed in this area doesn't lose that facility as far as the system is concerned. It has been said that similar steps have been taken in Australia, particularly I think in New South Wales. Clearly this is an idea whose time has come. As Leanne Dalzell has said, the Labor Party will support the legislation to select committee, but we will be looking very closely at the question of how this system will be rolled out, what sort of technology will be made available, and those practical deployment issues, so we don't lose the essential fairness that you need in the justice system when you're making assessments about whether in particular a witness is telling the truth.
Mr. Speaker.